We're not done. We got at least one more. You know, the ironic thing is, in this situation, the consideration of collegiality, right? In this comportment, I'm in an executive role. I'm not a judge. I'm not a lawyer, right? But what if I was working with somebody? What if, in order for me to be able to do what I needed to do, I needed an attorney general, a prosecutor, an investigator, a pipe inspector? They had this kind of information, and this is what happened to them. I don't know what the problem is. I've never seen my people as poor and incompetent. I am arrogant enough to believe that this is who I'm supposed to be working with. And I'm also conceited enough to believe that I have not only the right, but the power to do something about what they've done to her. So let's keep reading. So, last night, apparently, there was some efforts to prepare for what she was hoping to do today, to create a motion to file. And in the course of that, she went through what she had and she made some notes, and that's what's being reviewed here. So in case there was, for instance, you go to court and you have to argue it out, or there was a hearing, or there was a request for a brief, right? Something of these sorts of. Maybe if there was, understanding as I do, for instance, that the Court of Appeals has an annual praxis wherein it composes reports for the Senate and House Judiciary Committees, and that it may be part of an ongoing process of consideration of very important matters. Oh, wait a second. Didn't this person actually contact the Senate Judiciary Committee? Yes, she did. Right? Years ago. Right? And she also did this thing where part of the procedure is that, at least in the local district court, each judge has their own rules when it comes to submitting motions. And while there was this magistrate judge that kept insisting that consent was not needed for her to just automate the case, that the presiding judges in each of the cases, including this one, had their own rules and procedures listed about what it meant to submit motions before their court, including an understanding that some of the judges had what was identified as a judge's copy. Now, understanding that different judges preside over different areas of specialty, and that providing a specific copy for the judge themselves has a very specific meaning regarding what the proceeding is about. And I anticipate, especially if there were to be more forthcomingness on it, the surety associated with the case. That there is a specific manner in which a copy is provided to the judge that is distinct from what is the court copy and your copy for the official file. What this means specifically? Well, she did this. She composed this letter, but there was the situation. You're not allowed to have any money, and the technical legal process is to send it in via the mail. You can go down on site. You can submit it on site. You can have it timed, stamped on site, but there's a different process that comes with service or delivery via the mail. And at that time, the explicit rules regarding this specific judge required post mail. What happens if A, you don't have the money for that kind of postage? B, you've already had your mail sabotaged through the USPS, especially when it comes to your actual efforts to file. I don't know, sending a 300-page package to the Department of Justice. I don't know, trying to get your birth certificate, buying a money order, and getting a notice in the mail back from the state of concern that they never got the money order with the original request. Those aren't just acts of mail fraud. The two major concerns. So she wrote a cover letter, handwritten, delivered it by hand, on site. This was supposed to be delivered directly to the judge, but that's not what happened. When it was filed and it was put on the electronic filing site, not only did they document that it was submitted on the wrong date, but they classified it in the wrong manner. It is as if to say, Poor pauper woman. This is how she understood it. Oh, no. This is how I understood it. Poor pauper woman. You're making a personal appeal to the judge to give a special consideration to your hardship case. We're going to put it on the public record so everybody can see it. That's literally what I understood they were doing. They wanted to make a spectacle out of it. Is he going to get back to her? How's he going to treat her? What's he going to do? See, the specific, explicit understanding is it was meant to be a direct copy to the judge. If you're requesting articles of impeachment or a criminal indictment, it makes a big difference when you have a secure process to submit a sealed indictment than when some clerk of the court mischaracterizes it and puts it into the electronic filing system so anybody can see how bad my handwriting looked on that day. It's unnecessary and it's unprofessional. And it's against the explicit rules not only of federal procedure, but also the local rules as well as the special instructions from the judge, who, by the way, to this day, has never responded in any way, shape, or form to any filing with his name on it. What does she say in this particular request for motions to transfer, for leave to file for new trial, for consolidation of cases, and for confirmation? Dated for February 27, 2020. Krause contended in her original request for leave to file motion for new trial, case number 3:19-CV-02280-K, that a new trial was being requested concerning repeated abuse of the electronic filing and other filing processes via the Supreme Court of Texas, as well as the Southern District of Texas U.S. District Court, for going on what had been over 2 years at the time of the original filing in the Northern District U.S. District Court. Going on. Krause contends that there is now a preponderance of evidence to demonstrate that this manipulation of the reporting and legal process was actually a premeditated effort to traffic Krause as retaliation for her whistleblower efforts and in an effort to compel her to relent on her investigation. In addition, recent changes to Texas laws concerning access to public information have now served to intentionally violate many important reporting deadlines in consideration of sureties connected to response timelines, while also making any information on these acts of default confidential. Krause understands specifically that changes to Texas laws regarding ethics, open government, concerning exceptions to case information connected to verdicts involving political subdivisions, is in fact evidence of a conspiracy to commit crimes and to obstruct accountability for past crimes. Now, next is mentioned a case that actually has the same name as the magistrate judge, and this is exactly what the concern was. This specific case was entitled Ramirez versus Texas State Board of Medical Examiners. It is from February 27, 2003. In this situation, Ramirez was a doctor who was having problems with compliances with licensing. But the decade before this Ramirez case, and at least 2 other Ramirez cases, where the name Ramirez was posited in a manner that had a substantially different political capital for consideration in their intercession with the judicial branch of government, were a number of other cases regarding Ramirez, specifically connected to allegations of child sex abuse. How long does it take for a surety on a case about child sex abuse to accrue leverage? This is part of the concern. There was this specifically, the names Ramirez and Gonzalez are specifically and demonstrably indicated as having access to a certain kind of political capital before the trial, and it is as if there is a pattern of racialized targeting based upon specific kinds of accusations associated with those name references. The 10 years of the 80s, the 10 years of the 90s, and in the 10 years of the 2000s, before 2010, demonstrate that there was a pattern wherein associations during each of those decades remained consistent, but within the next decade got recharacterized to get recharacterized again. And cases more recently have also, in some ways, specifically when it comes to the name Ramirez, it's as if they have reverted back This is also similar to the name Gonzalez. There are other patterns of racialization that are apparent specifically within the Southwestern District, or what is recorded in the Southwestern District Reporter concerning cases that went before the district courts. They have this very racialized pattern. And what is noticeable on one hand in terms of what is included and how it is characterized, especially when it comes to surnames that are of Spanish descent, it's one thing. But what is also remarkable is how names that do not come from or are not derived from Spanish have certain things that are not present. There are certain kinds of racializations or ethnizations regarding case considerations that are just absolutely not represented. And this brings up questions of, is this about a regionalism? Because there's a very different pattern, for instance, in the district that includes Georgia and Florida and the Carolinas. That there's a very different kind of systematology regarding how they classify these cases, and there's a different kind of association with what is still apparent as a pattern of distinction in terms of names that have Spanish backgrounds versus names that do not. But there's a different implication. Being a Ramirez in 2003 in Texas was different than being a Ramirez in 2003 in Florida. And this is what has been unfolding for a long time. So these specific charges at this specific time to be disproportionate or to be inexplicably allowed to be remanded to an automated process before a magistrate judge that is so identified, it would have behooved that magistrate judge to have taken these considerations seriously before they were allowed to proliferate for another year. Why? Krause's original petition for writ of habeas corpus, WR-87139-01, Texas Court of Criminal Appeals, 2017, charges that Krause was intentionally denied any due process so as to prevent an evaluation and judgment of her grievances during the period of the Sunset Review. The legislature of Texas is required by law to periodically review various commissions that it authorizes, including the State Bar of Texas, including the Texas Board of Medical Examiners, which allegedly was later renamed the Texas Medical Board. It was in this time frame in 2017 that request was made for consideration of breaches of policy committed by people that would have been accountable to those commissions and the structures over which those commissions saw. So going to the claim that there was no claim or that it was frivolous is Krause contends that 1. Assignment of case number 3:20-CV-00113-X and case number 3:20-CV-00114-N to a magistrate judge for charges of this degree is inappropriate, as these are not minor offenses suitable for review before a magistrate judge. 2. Assignment of both cases to the same magistrate judge is a conflict of interest and in violation of the expectation of conducted explicated in Don D. Properties Corp. versus Commerce Savings and Loans Association, 128 FRD 284, Northern District of Texas, 1988. 3. No legal basis exists for willful violation of Krause's rights to due process by repeatedly denying her legal reporting process, legal evidence submissions process, legal counsel, including in the form of interview with a district attorney, prosecutor, or lawyer, legal closeout reports on open investigations that have not been responded to within legally mandated reporting periods, while the laws governing the reporting bodies of concern have been changed, no access to a means by which to provide herself with income that does not attempt to extort her into agreement to commit illegal activity, including in the form of accepting kickbacks connected to former reporting efforts now repackaged as contracts or offers that attempt to extort her into agreement to assist others with attaining kickbacks, and no way to proceed via judicial process without having to agree to pauperdom in lieu of being provided assistance or personal income so as to be able to pay filing fees or court costs, which are necessarily substantial in consideration of the need. 4. That the actions of Judge Irma Carrillo Ramirez are further indicative of the use of Krause's filings and derivative actions, despite Krause's express request in her request for disciplinary action per reference to her original request for leave to file motion for new trial, that such not be done and why. That evidence of this is that no instruction concerning special orders is available per the local civil rules of the court for the Northern District of Texas U.S. District Court, but can be found in the local criminal rules of the court, and that the failure to provide Krause timely access to her rights to due process And habeas corpus relief in this manner has aided and abetted violations of Krause's rights concerning perpetuities, per Section 26, perpetuities and monopolies, primogeniture or entailments, as well as Section 12, habeas corpus, and Section 13, excessive bail or fines, cruel or unusual punishment, open courts, remedied by due course of law, of the Constitution of the State of Texas. While these speak specifically to the Constitution of the State of Texas, it was for violations by the Texas judiciary of the Constitution of the State of Texas that Krause originally sought remedy through the federal district court system, and it is in accordance with violations of these rights that the pattern continues to be perpetuated, as the reference to the specific case herein attest. This violation of Section 26 of the Texas Bill of Rights and the means through which it was accomplished in the Northern District of Texas U.S. District Court now represent the second violation in less than 10 years. After this, what does it say? So those are all points. I don't know. Do those state claims? Now, the ironic thing is that these specific claims were not the original claim. The original claims had to do with abuse by the Texas state legislature, and the federal judiciary was being sought in an effort to provide a remedy. Now, does someone want to say that the district court does not have jurisdiction to file articles of impeachment? Well, we never got to that argument. She tried to later say it had to do with an 11th Amendment prohibition. It's not about the 11th Amendment. But because we never got past the complete broach of and the completely incomprehensible repudiation of anything about acknowledging even her professionalism in consideration of these charges, there was never an attempt to actually present the argument that had already been prepared concerning how the federal district court did in fact have jurisdiction to assist with correcting for violations of the Texas Constitution that the judiciary of Texas had been responsible for in its failure to deal with the matters that would have been brought up as part of the motion, leave to file a motion for a new trial concerning how they were addressing within the Texas judiciary crimes that were being committed as part of the abuse of the electronic filing process. As this is actually an argument. There is actually a constitutional claim regarding jurisdictional considerations. This also has to do with what I will say in the final video afterward concerning these things that were not put in the original request that she made, but that are absolutely relevant and get back to the specific claims that will be addressed in the next one. But the point of the matter is these are claims. Would anybody argue that these aren't claims? Now, do you want to say they're not facts? Okay, do you want to say that they're frivolous? Next, the recent discovery of the case information regarding Ramirez versus Texas Board of Medical Examiners, as well as numerous other cases, demonstrate that the pattern of racketeering activity with which Krause has been trying to seek assistance in prosecuting involves similar violations of the Constitution of the United States, including in commission of crimes going back more than 2 decades, specifically and demonstrably evident in regards to Krause herself as the primary vehicle through which these crimes have been committed. Under federal RICO statute, a conspiracy can be demonstrated via the use of the same vehicle. In association with the attendant acts of securities fraud is consideration of Krause's efforts to report on allegations of securities fraud involving a brokerage with the same surname as the attempted magistrate judge of concern. In case number 3:20-CV-00113-X-BH, in case number 3:20-CV-00114-N-BH, as well as other persons. It's also important to know that Krause also understands that there were bonds issued by this specific brokerage that had a very important timeline associated with their maturities that occurred around the time she attempted to go to college and happened to meet somebody that was actually from the very area where these bonds were first issued. They met at the time of the maturity on these bonds. Finally, As such, there is overwhelming evidence that the assignment to a magistrate judge and efforts to repeatedly and with strategic timing attempt to do so should be considered for their potential culpability with the allegations first submitted on September 24, 2019. The nature and duration of these crimes are significant enough to warrant transfer out of a court of civil consideration and into a court for criminal prosecution. As such, Krause requests leave to file motion for new trial in granting of the herein requested motions. Krause additionally requests leave to file indictment under seal per local criminal rules 55.3b1. Now, that would have been her response, right? Some of it.